and was that director of training at a time when this type of training was just getting started. Please welcome Steve Rench.
Tomorrow, you, each and every one of you, are going to deliver the greatest speech of your life. You are going to connect with that jury. You are going to do it without the handcuffs and the shackles and the body armor that we use to make sure that we don't forget. We're not going to memorize. We're not going to read. We're not going to be focused on the notes. It's my job to tell you how to do this. I'm going to do that in just a little bit. But first, I want to talk to you just a few minutes about the elephant in the room. And that is the culture of losing. Throughout this country, criminal defense attorneys expect to lose case after case after case after case. I was down in Arizona not long ago to speak to a seminar. The president of the Arizona bar, a criminal defense bar, invited me over. I didn't know him at that time. And he said, "What are you going to speak on?" And I said, "I'm going to speak on winning criminal cases." And he looked at me in puzzlement and said, "Isn't that an oxymoron?" I've been at seminars where it's announced that somebody won a case. And we applaud like it is a tremendously rare event. Unfortunately, it is pretty rare. Now, would I be talking about a losing culture, etc., if I wasn't going to give you a way to have a winning culture? And the answer is absolutely not. But I need to discuss just a little bit more what it is that causes us to lose and lose and lose and lose. And that is that we went to law school. Now that you've gotten some idea of what I think of the training that you get in law school, let's talk about it. Their great pride is that they taught you to think like a lawyer, which meant what? To think like them. And above all, not to think like a human being. That's their objective. And the reason for this is that back in 1871, which is a long time ago, at Harvard, they decided on the case method. And at that time, they were interested in teaching only one thing, the law. Not out of practice law, just the law. And Christopher Columbus Langdell, who was the dean of the Harvard Law School at that time, was the proponent of the idea that law is scientific. It is mathematical. If we can only figure out what the ruling ought to be, it is 2 + 2 = 4. And therefore, they wanted no emotion to be interfering, no feeling to be interfering, no humanity to be interfering. And so for 3 years, you mindlessly and continuously, as did I, go through learning to think like a lawyer. Well, actually, I was lucky, because 4 blocks down the street, there was practicing the greatest trial lawyer and appellate lawyer of any time since Clarence Darrow, and that was Edward Bennett Williams. And I saw how to really try cases as opposed to what they were trying to tell me in the law school. And so the humanity is sucked out of us. I know that your instructors during these 2 weeks have been telling you over and over and over again, that sounds like a lawyer, eliminate it from what you do. But I doubt that they have been telling me that the reason we lose is because we think like a lawyer. Now, let's talk, after we get that out of the way, about winning criminal cases and how we do it, because obviously it is going to require a paradigm shift in what we do in order to do closing argument and indeed every other part of the trial. You have been given all kinds, hundreds of suggestions, but they're kind of ad hoc suggestions during this 2 weeks. I want to suggest to you a label that will make it possible to take all of these things and put them in your toolbox, and that is the persuasion method, because everything that you were told during this 2 weeks, everything that you are going to do well for the rest of your careers is based on persuasion and choosing that which is most persuasive. Now let's talk a little bit about persuasion. You're going to be my jury, okay? Right here. You've never been to law school, all right? Never been to law school. Why am I telling them they've never been to law school if they're going to be my jurors? Because lawyers don't think like jurors, and jurors do not think like lawyers. Jurors have belief systems that they have developed in 40 years or 50 years or 20 or 70 or whatever it happens to be. That is their age minus about 18 months. They have belief systems about the schemas, the way things operate in the real world. And if we are going to be persuasive in building a case, we must build a case not on the foundation of the legalisms, not on the foundation of legal analysis, not on the foundation of legal concepts, but we must put together a case that fits into the belief systems of our jurors. For if what we do is to put together a case in terms of legalisms and legal concepts, and they do not have that as part of their belief system, what we know from every study that has been conducted is that it is not persuasive. And so we need, between now and tomorrow, to re-examine our theories of the case and how all of these things put together. For we need to have that case which you're going to express and put together in the closing argument. You need to have that case which fits into the belief system of the jurors. Now, not only do we need to have that, but there's more to the persuasion method than that. As a matter of fact, there's an awful lot to the persuasion method, and we're going to deal with only a brief part of it. The jury jury is not going to be persuaded by what I call naked points. That is, we express points to the jury. Every time we have a point, we must take that point and develop it in depth. We must come up with visuals, inferences. We must come up with everything there is that will support that point. And the reason for that is that if you express something one way, one time during a trial, count on it, folks. It will never get into the jury deliberation room where the real contest takes place. And so you must learn power language. You must learn to have impact. You must learn all of the support that it takes to make that point so that the jury will never forget it and so that it becomes dominant in that jury deliberation room. That I call the multiplier effect. And the multiplier effect is this. You have a point. And a particular multiplier that I'm going to be talking about here during closing argument is juxtaposition. Juxtaposition. And here's what I'm talking about. The vast majority of closing arguments consist of scattered arguments. Unfortunately, what we do is we write out a closing argument. It isn't separated into bullet points. It's written out. And indeed, even if we express the paragraph, when we write it, it doesn't come out paragraph for the jury because of what? Because we are afraid of silence. And we're afraid to have the transitions between one point and another point and to tell the jury that we are shifting from one point to another point. And so we are going to make use of juxtaposition. And what you do is you take all of the inferences, all of the visual aids, all of the sloganizing, all of the impact language, everything that goes to the point that Judy Dodd is not to be believed, and we are going to put it in one bullet point. We're not going to scatter it around. It's a bullet point, and you scatter it around, and it's a pillow point. And it has little effect on the jury. We're going to talk an awful lot more about how to do that in just a little bit. But what I wanted to tell you was that these multiplier effects, for example, juxtaposition, I suggest to you that if we have something that carries 5 points scattered throughout in persuasive power, 5 points in persuasive power scattered throughout a closing argument, and we juxtapose it. We put the facts that make this particular point one after the other next to each other. There are 5 facts that demonstrate that Judy Dodd is not to be believed. 1, listed 2, listed 3, listed 4, listed 5, listed. Let's talk about them one at a time. When you do juxtaposition, I guarantee you the multiplier effect is at least 5 times what it would be if it's scattered around. And folks, we are getting on to what it takes to win criminal cases. If you're kind of a nut, and instead of reading good novels and so forth, you read about the great trial lawyers of the past, as I did. You can say that's weird if you wish, but that's what I like to do. You will find that there is no great trial lawyer in history that has made their closing arguments, indeed their case, on the basis of legalisms like the prosecution failed to prove each and every element beyond a reasonable doubt as their central theme. Not a one. Aristotle was not a lawyer, but he deserves so much credit for telling us about persuasion. But if you go through the centuries, people like Cicero, Clarence Darrow, Edward Bennett Williams, Daniel Webster, Rufus Choate, Joseph Choate, the great lawyers of the past. And by the way, their closing arguments are available to you. And you search through them, and you will not find reasonable doubt as the central theory of the case. You will find that they understand the multipliers, how it is you take a point, and where the ordinary lawyer would get 5 points for it, you get 25 persuasive power points. Notice that I'm speaking a different language than the legal language. I'm talking about the language, the vocabulary of persuasion. I'm talking about power. I'm talking about persuasive power. I'm talking about how you put together the multiplier effect. And combined with all of these things that you have been learning during these 2 weeks, what I can tell you is that there is a method that the great lawyers down through the centuries have used. And it is that each and every one of them was a great persuader. They understood that they built their cases for the belief systems of the jurors. They understood that they needed to take the points and to use the devices which are available to us, and not all that hard to do, to make those points tremendously powerful. For those great lawyers, I'd like to tell you that this is all mine, okay? It's not. The great lawyers through the years, the great persuaders, the people like Aristotle, taught us how to persuade. And what I can tell you is that when you use this kind of method, if you will excuse my immodesty, in the public defender's office, I was winning using this kind of method at least 5 times, not 5% more, 5 times as many cases as were my colleagues who thought that the great central argument of all time was the prosecution failed to prove each and every element beyond a reasonable doubt. So what I'm telling you is, there is a way to win criminal cases. Take what you have learned during this 2 weeks and put it in your toolbox of the persuasion method. If you want to call it something besides the persuasion method, the reason I call it the persuasion method is that there is no device whatsoever, no tool that we would suggest to you that isn't persuasive, right? That's why I call it the persuasion method. And I think it helps to have a feeling that there is a method that includes all of these things as just not ad hoc tools that we use. Now, having said that, and suggesting to you that there needs to be a paradigm shift insofar as you haven't made it yet, from being a lawyer. Fine to be a lawyer in the appellate courts. Fine to be a lawyer when you're arguing to the judge. Fine to be a lawyer when there's an evidentiary issue. But when you are before that jury, I beg you to have a paradigm shift to becoming a persuader. Now, having said that, and you see, if I hadn't said that, a great deal of what I'm going to say about closing argument would not really be that understandable. Closing argument, how powerful is it? And I recognize full well that you have probably been to lectures where they say, well, you can lose on closing argument, but you can't win on closing argument. And for those people, I would say they have no idea how to give a closing argument so that they are a true believer pouring out their heart for Larry Baker, Brown, Bonnie Kitchens, Mario Dodd, where you can win case after case after case, where you are behind at the beginning of the closing argument. It is the last thing, the last time that the jury hears from you. That's recency, isn't it? The most powerful place in the trial, except possibly the beginning. But I suggest to you that recency trumps primacy when it comes to that. Now, there are those who call this part of the trial summation. Please understand, I'm against the death penalty. But those people who call it summation, I wouldn't mind seeing them lined up against the wall and fire around them. Because when you have the concept in mind that it is a summation, what do? You take the evidence which has been presented. The witness X said so-and-so, and the witness Y said so-and-so. And it is the dullest, most unpersuasive stuff. What you are going to do tomorrow is argue. And by the way, I've been thus far giving emphasis to things by making it have greater volume. I should hasten to add, parenthetically, the most powerful thing you can do is barely above a whisper. And so it is important to have a whole range of tools for the closing argument. Closing argument, the judges tell me, and I see it when I go to court, is extremely poorly done. Basically because it is not organized. It's just written. Or just given. It is not organized into bullet points as it must be. Let's talk a little bit about content, but only for a moment, because take all of the content that you have gotten during this time, everything that you've gotten on cross-examination, everything that you have thought of in your theory of the case. You want to make use of everything that is available to you and draw inferences from it. For the closing argument is the first time, right, during the trial that you can argue. It is the first time that you can draw reasonable inferences from the facts. And folks, I have made a career of those inferences. It allows you not room for imagination to come up with the innocent way that things did happen, whether it's that way or not, it allows you to put together a case that makes sense to the jury and causes them to say, yeah, this is the way that it happened. I mentioned a while ago of how when we have points, as far as I'm talking about the content now, when we have a point, our temptation is to just tell the jury that point with minimal support, some support. And I hope that what we have done during this 2 weeks is to convince you that when you have a naked point or one with only a certain amount of support, that you are going to work with your imagination. You are going to pull in every single thing that supports that point, and you are going to drive that point home. That's what the content is about. Now, powerful arguments. Powerful arguments. You've already gathered what I think of the central idea that, and simply because of where you're sitting, not because you have any inclination this way, this argument, the prosecutor failed to prove each and every element beyond a reasonable doubt. Around this nation today, this is the central theme of almost all the criminal cases, in spite of the fact that we have been losing and losing and losing and losing. Now, I'm not saying that you don't use it at all, but why do we have these rules that the burden of proof is on the prosecutor beyond a reasonable doubt? Why do we have them? That's what I thought. The real reason we have it is to protect against the conviction of innocent persons. Fair? And so we shift our way of trying cases from the standpoint of a procedure. The prosecutor failed to prove each and every element beyond a reasonable doubt, to taking the position that Johnny didn't do it. The difference in the cases you will win simply because of that one position. Now, I understand that you may be going for a lesser included. I'm talking about that he is innocent, at least of the charges you want him to be innocent of. Let's look at what happens in real life. Where I will tell you, I watched at NITA some probably 70 hours of deliberation, not by real jurors, but by people who came off the street. Probably 70 hours I have watched deliberation. How many times in that 70 hours do you think that I've heard the jury discuss who had the burden of proof? How many times do you think that the jury has made a list of the elements and then said, we don't care whether he's really guilty or not. What we need to do is to go through each and every element and see whether it's been proved beyond a reasonable doubt. Is that the way people operate? Well then, don't we have an unrealistic system if we are arguing to them as if that's how they do it? No, the jurors have a much less legalistic way of doing it. And that way is, if Johnny did it, they want to send him south. If Johnny didn't do it, they want to send him home. And I suggest to you, proof beyond a reasonable doubt isn't a test. If your jurors can find your defendant guilty and sleep well that night, then you are going to lose. Fair? Yeah. Because jurors don't think like lawyers. And they don't go in there. And so when we are making an argument to the jury in terms of legal analysis. Look at the situation. This is real, folks, real. I'm talking about reality. So the prosecutor puts Lucy Myers on the stand, and Lucy really has been raped. It's just not by Johnny. Lucy really has been raped, and Lucy has tears. And Lucy is a sympathetic figure. And that's the story that the jury has of the prosecution's case. What do we have in opposition to that? The prosecutor failed to prove each and every element beyond a reasonable doubt. If there ever was a mismatch in history, me fighting Mike Tyson in the ring is not that great a mismatch. And so, we need powerful arguments. Let me tell you about a civil case. A civil case because it may be easier to see it. And I was only the coach. I didn't represent Michael Jackson. I was the coach in a case where Michael Jackson was sued for copyright infringement on the song called Dangerous. In Denver, a young lady named Crystal Cartier did compose a song called Dangerous. And as she was going home one day, she heard on the car radio a song by Michael Jackson called Dangerous. And she decided that Michael Jackson had stolen her song, which took a lot of ego. But nevertheless, she thought she was a star. She really did think that she was a star on Michael's level. Anyway, we're getting ready for court. And we have a mock jury, and they call me in at kind of the last minute as an afterthought. And on this jury, we have 3 older people, 3 younger people. Now, our hero in this case is Rich. Rich is an associate, and he's conducting the mock trial. So, here's how he does it, because I can tell you, there are few people who have a greater left brain than Rich, and who has less of a right brain. I mean, he is a lawyer, Princeton, Harvard, and all that, but really good there, too. I didn't finish at the bottom of my class, okay? But he says to the ladies and gentlemen of the jury, we're going to play 2 songs and ask you whether these 2 songs are substantially similar. Now, why did he do that? Because it's right out of the law. Okay? So they play the 2 songs, and the older people on the jury say, well, yeah, they're substantially similar. All this crap that you youngsters is substantially similar. And the younger ones, of course, say, there's no similarity between these 2. So I called Rich over and I said, Rich, ask the jurors if Michael Jackson stole Crystal Cartier's song. Notice the difference between substantial similarity, all the legalisms and so forth, and something that strikes home and is understood by the jurors and fits into their belief system. Rich is not to be denied. He says, now, ladies and gentlemen of the jury, did Michael Jackson copy? Why? Because it's the law. And Rich can't think in anything juror terms. It has to be in legalistic terms. And the jury still is, nobody cares, really, but it's 3-3. I said, Rich, I don't care, and I'll explain it to you later. I don't care what form of the word you use. Stole, steal, stolen. Just used the word, and he asked him if Michael Jackson did steal Crystal Cartier's song. And there was a change in the body language, and all 6 of them said Michael Jackson did not steal Crystal Cartier's song. And so that became our theme. And that's the kind of theme you want. And of course, Michael Jackson, we did win for Michael Jackson. And here is jury in the paper. Jackson did not steal Dangerous. That's what you want. You want your theme to come across so strongly that the newspaper reporters are going to get it and the whole country gets it. And so the other newspapers did it the same way. This artificiality of the legalisms and legal analysis and operating as if the jury carries out this way is responsible for our losing. Let me do one other thing that will demonstrate how artificial this is. Who has a son or daughter, 5 years old, 6, okay, name?
Leela.
Leela. Okay. So, your best friend. There's a celebration. You have a beautiful cake for your best friend. The guests are going to arrive at 8 o'clock. It's, the frosting, everything. The guests are going to arrive at 8 o'clock. And about 7:30, you notice that a whole handful of the frosting is missing. And you say, Leela, did you take the frosting? And she says to you, you can't prove it beyond a reasonable doubt. Poor Leela, I attributed too much to you, but you would not Leela clear through the wall. How artificial all of this is. And what I hope you don't do is to go back home and become a lawyer again. I want you to become even less of a lawyer. Organization. Basically, the macro organization of the closing argument is first the hook. It is something brief which expresses the justice of the case from your standpoint. The second part are the arguments. And after the arguments, the final appeal. Okay, the hook. What was my hook today? Tomorrow, you are going to make the greatest speech of your life. I hope that did something to get your attention and to get you thinking about closing argument. Now, the arguments. Crucial contested issues, and this is my name for it. You go through the case. You think of the crucial contested issues. Crucial because they're going to make a difference who wins. Contested because you and the district attorney are against each other on these issues. And what you want to do is to win on the crucial contested issues. And so your arguments are going to be your side of the crucial contested issues. This gets you so that you are hitting the nail on the head as far as what is central in the case. Those become your argument points. And we'll be talking to you about there being bullet points, making them into bullet points. So we've got the hook, the arguments, and I'm going to discuss the arguments in a great deal more detail in just a minute or two. But the third part, the final appeal. This is the very last part of your closing argument. And you need to work on this because it makes so much difference. I suggest, well, you're going to have gathered, it's going to be in terms of Johnny didn't do it. It's going to be in terms of innocence. It's going to be slower. It's going to have more emotion. And this is one that I had back when I was in the public defender's office. And yes, I did talk about the instructions for just a moment. Say I'm not going to discuss them, but there is one instruction that I need to talk to you about for just a moment. And that's the instruction on reasonable doubt. So you see, I don't have reasonable doubt completely left out. It's just a supporting actor. And you'll gather how it's a supporting actor when I finish this off. And you tell that jury that instruction. As a matter of fact, every single thing that we have done in this case has been for one purpose, and one purpose only. And that is to ensure that no innocent person is unjustly convicted. That's all I ask of you. That's all Johnny asks of you. But when you finish your deliberations, that you can say in your heart and in your mind and in your conscience that no innocent person has been unjustly convicted. Okay. If you're not getting response from the jury at that point in the game, send somebody else to take the verdict. There are people who take this down and they try to do my final argument, and you can't do that. Okay? It's not because I copyright. No. It is because you need to come up with your own, that fits your own rhythm, that fits your own way of thinking, that fits your own idea of what that final appeal ought to be. Now let's talk about the arguments, because this is central to what I want you to do tomorrow. And by the way, you have 15 minutes, which means you are going to be able to give the entire closing argument. So I suggest that you have a hook, that you have an argument or two, not many, because guess what? You are going to develop this one or two arguments to a far greater extent with the inferences and everything that supports it than you have ever done before. And then have a final appeal. Okay? I suggest that you not try to skim a whole closing argument into 15 minutes. Leave out arguments. Just pick those arguments that you are going to make powerful. Now, how are you going to build an argument with all of this force that I'm talking about? That Judy Dodd is not to be believed. Well, first of all, you need to state the point. State your point. Carefully work out the wording of your point, because that point that you are making is going to become a theme. And what I mean by theme is that which is repeated, either in exact words or in idea. And why do I tell you state the point? Isn't that obvious? And here's what happens to people. Not just once in a while. I mean, almost every closing argument that I see here. The attorney just gives that which supports a point, followed by the next argument and that which supports that argument, without ever telling the jury what the points are. And I was training director in the Colorado Public Defender System, and I would say to them, why didn't you tell the jury the point? And what was their answer? Well, it's obvious. Obvious to whom? Obvious to the attorney who's been working on the case, but not obvious to the jury. And so to the jury, it appeared to be one accumulation of a bunch of facts and arguments, etc. And so what we must do is to state the point, and after we have stated that point, then we are going to marshal the evidence. We are going to include the inferences. We're going to use every speech device. We're going to use every single thing. We are going to take all there is, not scatter it around, but all there is and put it into this one bullet argument or bullet point. When I say that if you don't do that and you have it scattered around, it's like a pillow. It's like hitting her with a pillow. No, but if what you do is to have the point that Judy Dodd, not believable, and what you do is that you marshal the evidence, marshal the inferences, marshal the demonstrative evidence, marshal everything there is possible to make that point, then that's how you win the central, the crucial, contested issues. Well, isn't it good enough just to have it scattered around? Well, if you're satisfied with weakness, yes it is. But this is the way you do it with power. There are 5 facts that demonstrate that Judy Dodd is not telling the truth. And then you are going to build that argument. Now, while you are building that argument, there are a couple of things to keep in mind. Warnings, really. 1, do not contaminate that point. You are brilliant people. This is what will happen to you. While you are engaged in making the point, Judy Dodd is not to be believed, guess what? Brilliant thoughts will hit you. We do not want to postpone. I'm not talking about something that just happens once in a while, folks. And so what do? We go to this other point that just struck us. The jury doesn't understand that we switched points. And by the time we get back to this point, the jury has finally caught on to that which was going on before. Okay, our organization is going to be so that we keep the jury informed at all times of what we are doing, what point we are making. Now, included in this point, we need road signs. And so if we have 5 points, 5 facts that demonstrate that Judy Dodd is not telling the truth, then what we do is after, say, the second or third one, and we say the 3rd fact that demonstrates that Judy Dodd is not telling the truth. Guess what? That's repetition, right? And furthermore, what we know about jurors is they watch television, and there are experts in the field that suggest that they have no more than about 30 seconds of time that they are going to give. Okay? Without their attention span going south. And so, by the roadside. Now, throughout your points, you want to have your themes. Because if you state a point just once, the chances of it getting here are virtually nil. You must come at the same point, either in the same words, that's a theme, or having the same idea from several different ways to get that across, so that when it gets into the jury deliberation room, it is your arguments which dominate. Include refutation. The prosecution has said certain things. If they have an argument relating to Judy Dodd telling the truth, and they're claiming that she did, after you have made your argument is ordinarily, but not always, the time when you're going to say, now the prosecution tells you, but, and shoot down the prosecution. Well, refutation and attack must be an important part of what we do. When we finish the point, marshal the evidence, the inferences, everything there is, develop that point strongly. Then we want to close the point. Don't just go on into the next point. Close the point. If you have no better way to do it, change your tempo. And so, ladies and gentlemen of the jury, what we have shown you is that there are 5 specific facts that demonstrate that Judy Dodd is not to be believed. Now, guess what? We're not just going to go into the next point, and that's our tendency. We are going to have a transition, and we are going to pause, and we're going to change position before we tell that jury there is another point. There is not one attorney in 100, not one closing argument in 100, where there are transitions, where there are pauses, so that the jury can understand that this is a place where one thing ends, one argument ends, and another one begins. So I want to emphasize what a multiplier it is when you take everything that relates to one point and put it in one position, together in one bullet argument, and drive it home for that jury. Now let me talk about delivery. The study showed that 76% of persuasive power, this is a new vocabulary about persuasive power and so forth, I suggested become a part of you. 76% of persuasive power comes from the presentation, and only 24% from the substance. But I will tell you that that doesn't let you off the hook as far as substance is concerned, because you are not going to be able to make the 76 work without good substance. What kind of delivery are you going to do? Because I said at the beginning that what you were going to do is to have a delivery which wasn't focused on your notes, which wasn't focused on the process of remembering what it was that you said into the mirror the night before, or what you wrote down, and trying to remember what you're supposed to say to the jury now. But you're going to do it extemporaneously. That means you are prepared. You know your organization. Like, I have things like hook, argument, bullet points, developing an argument point, etc. The way extemp works is you glance down, you see the next thing, and you talk about it. Now then, what you're going to say is, I might forget. Okay? Therefore, what I better do is to really focus here. And when you do that, because of perfection, you don't want to forget, let me tell you that it's okay to forget. Because if you are a perfectionist and want to make sure that you do all of this stuff down here, you are not going to connect with the jury. And what did Josh Carton spend a half a day or so getting you to do to connect with the jury. So, I'm suggesting that what you must do is to trust yourself. If you know that the argument is Judy Dodd is not to be believed, and you have thought about it tonight, you're going to tell the jury, you are going to connect with the jury, and you're going to look them in the eye, and you're going to tell them about Judy Dodd not being believed. Now, I do know that you will doubt whether you can do that. What I know from seminars that I've done the same thing with in a lot of other places is that when people take me up on this idea that they're going to give the greatest speech of their lives, that they don't forget. They talk to the jury and they connect with that jury. What kind of notes do I suggest you have? These are what I call jog notes. And I will tell you that after you have the notes for your closing argument, leave spaces for when the prosecution back home, you don't have a prosecutor tomorrow, but places where you can write in red what the prosecutor said that you are going to refute. And these things work beautifully to allow you to make extemporaneous arguments. And it means that you are not scripted. It means that you are going to pour out your heart for Baker and Brown and for Dodd and for one that breaks my heart every year, Bonnie Kitchens. Not for here, but for when you go back home. Because in 15 minutes you don't have to worry about that much needing variety. But if you give a 30-minute closing argument and you do it at the same tempo, the same volume, in the same location with the same feeling, automatic pilot, you will lose your jury. So different points require different feelings, and these different feelings are going to bring different tempos and different volumes. And I'll do the crazy thing on that. And what the prosecution did was to go down to the state penitentiary and buck testimony against Mario Dodd. Now I want to talk to you about when Mario Dodd was arrested for a crime he did not commit. Notice the difference in the two arguments. The feeling is different, therefore the tempo is different, therefore the location is different, therefore the volume is different. And that's how you get variety. Tomorrow, you will have a number of choices and so forth, which I don't have time to talk to you about. But a couple of things will be clear just by mentioning them. You need appropriate emotion and energy. You're not just going through an assignment. If I had more time, I would play for you Martin Luther King's I Have a Dream. And I would suggest to you that that's the kind of energy, that's the kind of feeling, that's the kind of being a true believer that it takes for you to win criminal cases. If I had more time, I would talk to you about rhetorical devices, the things that Martin Luther King used, of Barack Obama. I told my wife before the speech the night he was elected, I said, I guarantee you he will have a trilogy. I guarantee you that first paragraph is going to be something about transformational, and that he is going to use speech devices. You see, those words don't accidentally happen. Here's what happened. Anaphora is the beginning of each sentence in a series with the same words. Triple, there is a power to triple. If you say the same thing, with part of it being different, but nevertheless it's the same thought, look at the power you gain from that. For those of you who doubt, for those of you who question, for those of you who have a concern, tonight is your answer. It's a formula. It's 2 + 2 = 4, which Obama knows, and John Favreau and his 10 speechwriters all know this. And so if you ask me how in the next 2 weeks you could improve your power 40% in the courtroom, I would say go to the library and get a book on rhetorical devices. It is so simple to learn, and it is so very powerful. Well, yourself may be the greatest instrument for your defender. That you are a true believer and come across as a true believer. I think that's 30% of the verdict, right at the start. You're being a true believer. So I've asked you to do certain things. I've asked you to take off the handcuffs, the shackles, and the body armor, all of this stuff to protect us from forgetting. And just pour out your heart according to the organization that you have worked out. I've asked you to connect with the jurors. If your connection isn't down here, you can connect with the jurors. And I've asked you to be a true believer. And if you do those things, you will deliver that greatest speech of your life. Now, what I know is that you may be saying to yourself, well, Barack Obama can do it, Martin Luther King can do it, other people can do it, but I can't do that. And so I want to talk to you individually and say to you individually that there is not a single person here who does not have the power tomorrow to deliver this great speech if you will let yourself do it. And I know that you're going to let yourself do it because in other seminars they have done that. And people who have never given a speech before give those great speeches. What it does mean, because I suspect that there's something about this that I'm asking you to do that you haven't done before. And so there's a certain amount of fear. Members of the faculty, if it doesn't work tomorrow, it's Rench's fault because I'm asking you to do this. It is not your fault. So try it. Nobody's life or liberty is at stake here. And once you get the feeling of being able to make the speech where you are a true believer, where you're connecting with the jury, where you're having the freedom to talk to them, once you do that one time, you will be able to do it for the rest of your careers, and it is a great feeling indeed. So, there's a certain amount of risk, isn't there? A certain amount of fear. Put the fear aside. Assume the risk. What I'm asking you to do is to dare to be great. For you see, I know that you are great.